Hello and welcome to the State Constitution Lab Seminar Series. I'm Brian Murphy, a Stephen Poland Fellow at the Brennan Center for Justice and an Associate Professor of History at Rutgers University, Newark. Our presenter at this seminar was Adam Sopko, a staff attorney with the State Democracy Research Initiative at the University of Wisconsin Law School. He joined us to present his paper on the supervisory power of state Supreme Courts. The State Constitutions Lab is a new initiative to advance interdisciplinary and comparative research into new methodological approaches in the study and understanding of American state constitutions and their seminal role in the development of democracy in the United States. Supported by the Brennan Center for Justice, we'll be holding workshops throughout the academic year. You can find us on the web at stateconstitutionslab.org. You can join our mailing list, catch up on our past events, and see what's coming up next. Be sure also to visit our friends at the Quill Project to see how they are reshaping research methods into how constitutions are written. We had a great group of scholars and thinkers join Adam's seminar. This video picks up with my introduction just before I toss it over to Adam. I really hope you enjoy it. Our guest for today, Adam Sopko is currently a staff attorney with the State Democracy Research Initiative at the University of Wisconsin Law School. Adam joined that initiative after clerking for Chief Justice Stuart Rabner on the New Jersey Supreme Court. He graduated from Northwestern Pritzker School of Law, where he was editor-in-chief of the Northwestern University Law Review. And starting this summer is very exciting. He's going to be an associate professor of law at the University of Colorado Law School, where he's going to be teaching state con law and state and local government. So thanks for joining us today, buddy. And Adam lives like 10 minutes away from me, so we're practically neighbors for the time being.
Yes.
I can load up your slide deck if you want to set up what the paper is about and
Great. Yeah, that sounds good. Well, first, Brian, thanks a bunch for having me, and just more generally for organizing this series of labs or experiments, whatever it is, and just for making space, I think, for all of us to come together. I think just creating more room for state con law is great, especially like this kind of interdisciplinary group is really exciting. I look forward to learning from everyone this afternoon, and then also in some of the other seminars. So this paper is part of a larger project. I think right now, for everyone on this Zoom, I think it's fair to assume that state courts are front of mind for many of us, as SCOTUS and frankly the federal government more broadly is kind of in a period of retrenchment, peeling back rights and policy guarantees from good government to bodily autonomy, climate, voting. There's just more attention on state institutions, especially state constitutions and state courts, as maybe a potential alternative to fill in some of the gaps that are increasingly opening. But where this kind of like thread of my research agenda focuses is that kind of attention on state institutions, especially state courts, is focused almost exclusively on just like one instance of their power, which is judicial review. So, construing a statute or a constitutional provision or something to resolve a legal dispute. Judicial review is really important, of course. It's just a kind of core aspect of what state high courts do. But I guess like the kind of premise of this thread in my research agenda is that it's not all that they do. And I think that by kind of just focusing on that aspect of state court practice, we risk kind of overlooking just other really important features of state court practice, for example, like their administrative capacity. And so this paper, which has been accepted, and will come out by law review and will come out essentially the latter half of this year. So still very much time to shape it and strengthen it. But the paper is part of this kind of broader project that's trying to identify some of these additional features of state courts and then evaluate just some of the larger questions about state institutions, like their power limits, their role in state government, and so on. But today I'll be talking about the chief source of the power behind their administrative authority, which, as the first slide and the title of the paper reveal, is called the supervisory power. Okay, so we'll just dive right in. So I know
I'm
everyone's
sorry.
really
Did I jump ahead?
no, that's great. No, no, that's great.
Sorry.
No, that's great. So everyone's really busy. I realize doom scrolling or doing whatever it is we're doing. There's a lot going on, just I guess just kind of competing for our attention. So I guess you can only take one thing from the paper and kind of like from our conversation today. It's this. It's that state Supreme Courts have a highly discretionary, flexible source of power that they use to manage and oversee the operations of the judiciary, called the supervisory power, and that they use this power in addition to that kind of day-to-day kind of humdrum of judicial administration for broader applications like enhancing rights and liberties, and that these more expansive uses of the power are generally defensible based on the institutional development of state Supreme Courts and the unique structure of state constitutions. Next slide, please, Brandon. Oh, next slide. Sorry. Great. So, okay, so to kind of unpack that kind of soundbite version of the claim in the paper, here's essentially where I'm going to go with the talk, is just explaining what the supervisory power is and where it comes from, then touch on those more kind of just the heart of the project of this paper, which is those more expansive applications of the power, and then talk about its limits, and then maybe just spend the last minute or so just talking about the implications. Next slide, please. Okay, so what is the supervisory power? So in the paper, I define it as the primary source of administrative authority for state high courts to oversee the judiciary. So it facilitates administrative tasks like managing court facilities. We've gotten some snow here in New York and New Jersey over the last couple of weeks. So determining like 3 inches, 2 inches, 15 inches, like when do we close a courthouse? Also personnel management. So COVID, in 2020, 2021, courts relied on their supervisory power to craft some like vaccinate and test policies for court for judiciary employees, and then also control essentially docket control, so controlling the workload of the court system as a whole. So the I think it's your right, the screen grab from the Pennsylvania Supreme Court, for example, that the court issued that this fall, and that was essentially using their supervisory power to fast track all election litigation this fall to make sure that it didn't, kind of slow down in the otherwise ordinary timing of litigation in the PA courts. And so, kind of taken together, it's what courts use to just oversee and control the court system's operations. But taking a step back, it is an independent source of power. So we talked about judicial review, construing statutes and constitutional provisions. But state courts also have other independent sources of power that perhaps might sound familiar. So, for example, regulating the practice of law. Also, in several states, the high courts have rulemaking power to craft rules of civil procedure, appellate procedure, and so forth. And these are all independent forms of judicial power. And so the supervisory power is just yet another I think sometimes understudied and overlooked, but distinct form of judicial power. So that's kind of a broad definition, but I go into more detail in the paper, and I'll say a little bit more in a moment. It was necessarily intended to be a pretty broad and adaptable source of power. Okay, next slide, Ryan, thanks.
Sure.
So turning to from what it is to where it comes from. So the key insight here is that the supervisory power has a basis in all 50 state constitutions and was the intentional result of a nationwide reform movement to restructure and reimagine state government that primarily took place during the 19th and 20th centuries. So about half of state constitutions expressly provide for the supervisory power, vesting the Supreme Court with supervisory power, supervision of the court system, other similar formulations. In the other states, the high courts construe more general language, like a vesting clause or multiple clauses together, like here in New Jersey. Um, Text doesn't tell us everything, though. So I think to kind of understand the supervisory power, it helps to consider just the larger institutional changes that I previewed that animated these provisions. And one quick note, that is New Jersey's 1947 Constitutional Convention, for those keeping track. So the supervisory power was the product of, as I mentioned, efforts to just restructure state government and all three branches. But a particular focus was restructuring state judiciaries. And that was prompted primarily just by widespread dissatisfaction with how state courts were operating and functioning at the time. I go into a little more detail about this in the paper, but in brief, state judiciaries were just really complicated, just their design. They were really slow. It just took forever to resolve legal disputes. And most important for the paper, they were primarily subject to the control of other branches, especially their judicial administration. And I elaborate on this a little bit more in the paper, but that led to some politicization and kind of use of the courts by the other branches for patronage. Again, fueling this kind of dissatisfaction. So for reformers, they had kind of three goals to restructure or kind of reimagine the courts. The first was just elevating courts to be a truly coordinate branch with the other branches. And importantly, that meant moving administrative control away from the legislature and the executive branch and giving it to the courts themselves, especially the Supreme Court. It also meant making them more independent. So this is where we started to see the advent of other forms of judicial selection, like elections and merit selection and so forth, and away from legislatures just choosing judges. The second goal was expanding what courts do, expanding the judicial role. And so this is where we started to see the drafting of certain provisions in judiciary articles that kind of stretch kind of generic conceptions of judging or what it is that we think courts do. So advisory opinions, overseeing legislative apportionment, participating in statutory reform, straight up provision of social services, and so on. And then the last goal was to give them more power. So to kind of realize these first two goals. So making them more independent and asking them to do more. Reformers wanted to give them more power. And so this is where the supervisory power comes in, giving them control over their own operations and to kind of oversee their own administration and to kind of navigate I guess you could say, the volatility within state government. So that's just a brief sketch of where it comes from. And I think also kind of helps us maybe gives a lens to kind of look at those broader applications. Okay, sorry, Brian, next slide.
That's okay. That's okay.
At the heart of the project. Okay, so on the application piece, the key insights that I show here are that Supreme Courts wield the power in ways that go beyond what we might just consider routine judicial administration. And the second is that high courts use this power both within resolving a dispute as well as just beyond case adjudication, so outside of any particular appeal or case. In the paper, this is a wide kind of varied practice, and in the paper I give a typology that kind of organizes this. But this afternoon, I'll just touch on just a few examples. So in that adjudication context, really common applications are we might think of as enhancing rights and remedies, facilitating the law development responsibilities of high courts, and then mediating interbranch relations. So on the rights and remedies front, a very common use of the supervisory power is expanding protections for certain individual rights via essentially ad hoc procedural rules or frameworks. So for example, in a criminal case, saying that juvenile custodial interrogation of juveniles must be recorded. And so that rule isn't coming as a result of the due process clause or some other provision in the Bill of Rights, but instead as a kind of rule crafted pursuant to the Supreme Court's duty to oversee the administration of the courts and through their supervisory power. Beyond rights, they also use the power to enhance remedies. So a case that I discuss in the paper in the introduction out of Massachusetts, the Supreme Judicial Court there just a couple years ago, vacated something like 25,000 convictions in a single order. These convictions had been entered over several years, and the court received a report that the drug lab responsible for all of these convictions had essentially been doctoring their tests and results. And so while vacating or reversing a conviction is not extraordinary, the court did use the power to issue such broad system-wide relief. So in addition to rights and remedies, I mentioned the kind of law development role. So as the kind of highest court in the state, Supreme Courts have a responsibility to kind of shepherd and develop law doctrine within the state. And so courts use the supervisory power here to essentially facilitate that by making it easier to decide what they want to when they want to. So that kind of cashes out as maybe reaching issues in a case that neither party raised or like the lower court didn't reach, or overcoming various defects in the case, like maybe things like waiver or justiciability issues like standing and mootness, and so on. And then as for navigating interbranch relations, courts use the power here to engage other branches. So a very kind of common, maybe kind of illustrative example would be in a case, maybe there's an issue with a criminal statute. It doesn't rise to a constitutional violation, but nevertheless, there's just there's just a defect or something wrong with the statute. The court might use its supervisory power to convene a task force of lower court judges, maybe from the particular criminal court, depending on the state. And then they'll invite representatives from the other branches to all come together to identify a way to address or amend or fix whatever the perceived defect is in the statute. Okay, so then so that was the adjudicative side. Shifting to the non-adjudicative side, so this is where courts are using the power outside of a legal dispute, oftentimes sua sponte. I think the use that's probably most familiar to folks would be the creation of so-called problem-solving courts or status courts or specialty courts. And so this is where Supreme Court will create essentially a subject matter specific docket in a particular court or before even a specific judge. Oftentimes courts are identifying what they see as a social problem facing the population of that state, mental health courts, gun courts, and they are oftentimes crafting less penal or harsh forms of treating individuals who move through these courts. They also will use it in areas where maybe the underlying subject matter is conducive to kind of expertise, tax courts, land use courts, water courts out west, and so on. Okay, next slide, please. Sorry, Ryan. So we've seen the kind of institutional development of state Supreme Courts elevated their political status, made them more independent from the other branches, more accountable to the public, gave them more power to oversee their own operations and engage in the kind of broader policymaking process within the state. And we've seen that Supreme Courts have used their supervisory power for broader applications beyond just the kind of humdrum of judicial administration. And I think the account in the paper and that I've kind of discussed so far is that this is a really highly discretionary and flexible form of power, but it's not unlimited. It is subject to the checking function within the state's political environment. So what that means is that there are state constitutions and like their structure provide a variety of tools and powers to both sanction and influence and in some instances control court authority, but also kind of sustain aggressive uses of judicial power in a way that we just don't see at the federal level. So name just a few that are likely familiar to everyone here. The vast majority of justices stand for some kind of an election. Even in states like here in New Jersey that rely on selection, that method doesn't suffer from some of the distorting effects like the Electoral College. With one exception, all justices are subject to mandatory retirement or term limits or both. And so kind of taken together, it just facilitates more churn as to who is wielding this power. And then of course, there's the genuine availability of constitutional amendment to alter and influence or even just reverse decisions that are deemed undesirable. One thing to note is that many of these structural limits that kind of control and limit the supervisory power came about during the same period that the power itself was kind of created and put into state constitutions. And so that reformist vision that produced the supervisory power also was responsible for many of its primary limitations. Okay, in the last minute or so, maybe just want to reflect on some of its implications. Next slide. Awesome, thanks. So I think in some ways, the account of the supervisory power that I sketch in the paper and that I've talked about here stretches maybe some of our conceptions of judicial power and courts. I think it's fair to say that account maybe looks a little bit more like what we might consider just generic policymaking. And I think for some that might raise some concerns about kind of institutional role or legitimacy. I do think, though, that to the extent those concerns or critiques kind of resonate, that they might flow from maybe just a certain baseline view of what it is courts do and the kind of power that they wield. That is, like, their only task is adjudication, and really the only tool available to accomplish that task is judicial review. So really something that is not that is just not judicial and not legitimate. So in the project, I try to show that state Supreme Courts have other sources of power available to them. Here, the supervisory power, one that's more flexible and discretionary, but importantly, kind of lacks that large blast radius from more conventional powers like judicial review, and is still subject to a host of external checks and overrides and ways to countermand or tailor uses of the power. So in his work on state constitutions, Judge Jeff Sutton, who I think was on a prior lab here, described ordinary judicial review as akin to putting up like a big red stop sign. In contrast, the supervisory power has been described actually by a former Chief Justice from Wisconsin as an invitation to dance. I think it's a little hokey, but I do think that it's a fair description in that kind of rather than excluding other branches from engaging in whatever the underlying policy issue is. For example, saying that a regulation violates due process or that a statute constitutes cruel and unusual punishment or whatever, and kind of ending the kind of policy dialogue around whatever that is, the supervisory power is capable of enhancing participation. In fact, some courts have explicitly emphasized that this kind of like discursive nature of the supervisory power is one of, if not its most important features. And I do think that there's a lot to be said for that account. Okay, I just want to be clear that the claim that I'm kind of making in the paper is not that this is some kind of like unalloyed good. I certainly recognize that like all aspects of judicial power, it can be used to advance things that maybe we might find desirable, as well as things that we might find undesirable. The claim that I'm trying to make in the paper is that this is just an overlooked but especially important feature of state Supreme Court practice that bears on some of those questions that I identified at the start, like what their power is, their potential, their limits, and their role within a state's policymaking apparatus. And I think now more than ever, it's something that deserves our attention. Thanks.
I'll just show the last one because it looks nice.
Oh yeah, that's the New York Court of Appeals.
We gotta have it.
That was if we were at the Brennan Center.
Yeah, yeah.
I recognize that we were in New York.
Yeah, yeah. Right. We have a. What I can do is, thank you for that. I can keep if you want to ask a question or make a comment on this paper. I can I'll start keeping track of a queue here. Who wants to? Does anyone want to be the first to jump in here? Let me ask this. Where's the most friction with the other branches in how this is, in what you've studied? Like what are the real flashpoints of tension, and like how has that evolved over time?
Yeah, I think,
The
um,
historian question.
yeah, yeah, I was gonna say, I
Welcome,
was gonna
welcome
say,
to the
I
interdisciplinary
don't think
side of
I
this,
quite
right?
studied it from that perspective.
Yeah.
Um, I think that it's fair to say, so maybe let me answer it. Maybe I'll answer it a different way, and you can tell me if this is responsive or helpful. There, I guess we could kind of, I guess, so one area where we see a fair bit of friction are, and this is not unique to the supervisory power, but I think it's just a source of friction that's common across really all areas of court, legislative, especially relations, which is anything that we could maybe just generally refer to as like fiscal policy. So something that is going to just cost the state more money, so to speak. I mean, so the easy examples here, Alex was talking a little bit about his experience in Connecticut with like education funding. I mean, that is one area that is just kind of like an ongoing kind of flashpoint between courts and legislatures. And so I think areas where we've seen some dust ups using the supervisory power have affected things like union relations on the civil side. On the criminal side, it's been not not so much, but I think that where we've seen dust ups on the or friction on the criminal side has been areas where there are more political incentives for the legislature to take a pretty strong stance, so to speak,
Hmm.
um, that the courts might be seen as taking too large of a role for the legislature.
Okay, that makes sense. Yeah. Let me see. We'll go to Alex first.
Thank you. My impression is that, at least in Connecticut, our state Supreme Court is much more deferential to the legislature than the United States Supreme Court is to Congress, at least these days. And so, if that's true nationally, which I don't know, but assume for the moment it is that one of the reasons why you have found this interbranch supervisory power one of the more prevalent uses of the state Supreme Court supervisory authority?
I certainly think that could be. And this maybe one of the I think one of the points in your question I think is a really good one, and one that is kind of driving this thread in my research agenda, which is kind of like how do courts how do state courts, and in particular Supreme Courts, interact with the other branches outside of maybe what we see in judicial decisions. And I think a kind of a hypothesis pushing some of this is that there's just almost like an attitudinal difference between how I don't want to sweep too broad, how many state Supreme Court justices view their role as opposed to federal judges, which is almost akin to like a problem solver, so to speak, that like they're part of state government and they're there to make sure that like the trains are running on time. They may totally have different views than other branches, but like, they're not kind of sitting on high theory and doing things like that. Like maybe we might associate more with, we might see fleshed out more in SCOTUS opinions. And I think the supervisory power is just one way that the judiciary can kind of effectuate that kind of identity or perceived identity, is rather than just striking statutes, here's a more supple tool that the court can advance its prerogatives or its views or whatever it might be, but in a way that ensures there's like kind of continuation of governance and kind of things continue functioning well. Even if there's total, just fundamental disagreement between the branches, this is just another way to do that.
Lisa.
So this is something I've thought about in other contexts before, but hadn't yet thought about in the supervisory powers context. So I was really glad to read your paper and to think about this. But I'm wondering if you think that there currently is, or if there should be, some relationship between a court's sort of prudential decision to exercise supervisory powers and the actual limitations on the judiciary in that state, whether it be a state by direct election or retention election, as you talked about, or an appointment process. In other words, should the exercise of the power fluctuate, or do you think it already does, based on the other checks and balances on the judiciary in that state? So if you have the ability to kind of not elect a judge because you don't like what they did, or to recall, that sort of thing, should it be state specific, or do you think it already is in any capacity?
Yeah, so I guess here I'll probably maybe just point to the political science. There's some great political science literature on this. There's a good book that I think is kind of persuasive by Laura Langer that kind of the kind of crux of her argument is essentially that the scope of the kind of the way, I guess the way she answers your question is exactly that it is state specific, that there may be some kind of universal baselines across states about how courts wield power, but that what she identifies as potentially the most potent or influential factor in terms of why in state X versus state Y you have courts saying the state constitution does mandate some level of education funding, but in another state it's a political question and the court just has nothing to do with it, is due to these structural political factors about how judges are selected, kind of how closely the branches are aligned or not aligned. The availability, John has written about this really well, like the meaningful availability of constitutional amendment, and so on. And so kind of like that mix does shape and mold what we might consider just broadly the contour of their power: judicial review, supervisory power, how broadly they understand their rulemaking power, and so on. I think a harder question, and maybe this is where what you were kind of getting at, and something I think is really important, is like how much weight, like how sensitive, like how are they weighted? How are each of these kind of factors weighted to where we can say, like, if you were to change the selection model in Virginia where you are to direct elections, what would that mean for the scope of their power? Or if New Jersey was to move to merit selection or something like that. I'm not aware of anyone who has like kind of taken up a kind of paper like that or like a project along those lines, but I think it would be huge and really, really important. I think it's really great question, important topic.
John.
Thanks. Yeah, so Adam, I've had the chance to look at the paper before, and I think it's fantastic, really important, and enjoyed looking at it a second time, which I guess says a lot, right, for the work that we do. Often once is enough. So it's a great project. I had two thoughts, I guess, on my second read. The first is a very specific one. You make reference to executive efforts to kind of play with the budgets of courts in order to rein them in, and that has an effect on the supervisory sort of power, I guess the punch of the supervisory power of the courts. And I'm just wondering to what extent that's a real meaningful limitation that's underrepresented in your description of the supervisory power. Because I know that there's some budgetary discretion that you emphasize that courts have, but what ultimately, right, the spigot is controlled entirely sort of by the other branches of government. And so what does that mean about the real power behind the supervisory power? And I think you make mention to it, but I wonder if it is doing more work in the background, both in terms of a sort of a chilling effect on what courts are actually willing to do with this power because they recognize their subordinate nature on a fiscal sort of basis. And so that's one thing. And then the second question, I think, is much more open-ended. It might just be a poor question, but the posture of your paper is very helpful in part because I feel like it's speaking to this dominant federal Article 3 perception of courts, right? And you're kind of blowing that up a little bit, and you're like, no. There's legitimate authority to do other types of activities besides adjudication and judicial review, and you convince me of that, and that's all fine and well. But on the other hand, I'm curious, and this I think goes to your normative stuff at the end. I'm curious if you were just to sort of create an independent standalone article instead of a patchwork of provisions that describe the supervisory power, but you were just to like affirmatively declare this is the supervisory power of this state court and it's going to include these things and have these limits, and you're just going to sort of create that very clearly and explicitly all as one big lumped power. Why would you do that? And what would it look like? And what would need to be the conditions that you would want to see in that power that would make it a constructive addition to state constitutional architecture, right? Because like that seems really, and that also seems real for how we know state constitutions function because they can change a lot easier and move. And so you've identified this phenomenon in a way, like you seem to be describing it as a sort of thing that's out there. But if I wanted to actually kind of grab a hold of it and make it into the thing that it should be, what would you want that to look like? And how would you guide me in figuring out what that would look like?
Thanks. And thanks for the second read. Your comments the first round were tremendously valuable, as are these points on the second spin. So on your first point, that's well taken, and something I'll probably want to think about a little bit more. I think it, to a certain extent, the answer to that question is probably unknowable without some kind of qualitative research into like asking judge, and it exists out there, right? Like there's the whole literature on like what role do retention elections traditionally, post Dobbs, it's changing a little bit, have kind of served as like just sleepy affairs. People, sometimes don't even vote and whatever. But despite that kind of lack of a kind of salient form of as an electoral check on judges, there's a whole literature on the fact that it is a very real perceived threat on state court judges. And so that's relied on a ton of interviews with judges to kind of suss that out. So I think to a certain extent, your smaller point, but I think is a really great one. We'd have to kind of maybe ask the judges themselves how much the looming threat, the possibility of the governor kind of wielding the budgetary pen in a more muscular fashion to kind of stick it to the court or whatever. How much work does that actually do when the courts are maybe pulling their punches with the supervisory power, or frankly, any form of power? I do think that we have seen examples where courts have faced a kind of threat along those lines and essentially called the bluff. So there's a famous one in Kansas. One of my slides had the New Yorker did a profile on it, where the court kind of just faced down the governor and the legislature. And there was a real threat of eliminating the supervisory power, slashing their budget. They did start to close courthouses. And the way that the court kind of navigated that was, I refer to this in a different paper as like soft power. The Chief Justice kind of used the soft power and just wrote a ton of op-eds, basically telling the public, like, look, here's what your legislature is doing for us, is doing to you. They're closing the courts and so on. But I think how it shapes the actual use or scope of individual uses of the supervisory power is probably a little more nuanced and supple, and something that I probably want to think a little bit more about. But I appreciate and so I really appreciate the question. On your second one, I think what would the ideal kind of like crafting this from the beginning? I guess I'll just kind of say two quick things. I think first, what I'm kind of showing in the paper is that this is a power, but what I'm kind of teasing out is a practice, which is like the supervisory power would exist even if tomorrow nationwide the courts just decided we're just going to stick really to the straight and narrow judicial administration. These more expansive uses, in which I think is kind of driving your question, is more of practice. And so how to kind of capture that practice in a constitutional provision, I think leaving I guess I would phrase them the way that they are, crafted the way that they are. But I think more broadly, what would the ideal be? I think what's kind of driving that normative section of the paper and this kind of portion of my research agenda more broadly is kind of like a pluralistic view of policymaking in the state, at the state level, that has a meaningful place for courts outside of just construing constitutions and judicial review, but something that more accounts for that in a somewhat more formal way. How you would draft an article, I think, because a lot of this is just kind of like norms and practice, is something I'd want to think a little bit more about, and is super helpful as I kind of like turn to the next paper in this thread. So but I think that's how I'm thinking about it now, at least. So I appreciate it.
Jay.
Thanks, Brian, and thank you, Adam, for a really informative paper. Really appreciate it. I took your point about the supervisory power can be used for ends that an individual might agree with or disagree with. But I just wonder, in the course of your research, if you ran across any particularly eye-catching or creative examples of the use of the supervisory power to achieve ends that, say, a progressive might agree with.
Sorry, I had any particularly notable ways that kind of code progressive, is that?
Yes.
Yeah. So sure. I guess some that would come to mind. I didn't really approach the project from that perspective, but I guess a few that would maybe come to mind, I think, are uses of the power to expand on individual rights. I think that kind of, which is like a kind of portion of the paper that I spend a fair bit of time on. In particular, kind of crafting what would be enhanced almost rules of criminal procedure. Almost always these were going above the level of protection you would get under the state constitution in that very same state before that exact same court. So giving like levels of protection above that, which is almost like the kind of like concentrated version of the like kind of shift to the states that we've seen, because not only are we shifting to states to enhance protections for the accused and the incarcerated, but courts are going even above what they provide under their state constitution. So I think that is the one, those broad uses, and I cite a ton of examples in the paper. Those would probably be the ones that jump out the most to me.
Ron shared so Ron, just so you know in the chat, Ron shared a piece by, oh gosh, by David Wildstein, about a directive from the administrators of New Jersey's courts. It was like in the opposite direction of what Jay was just asking about, saying like the legislature had offered a plea bargaining option on DUI and DWI cases, and the administrator of the court said no, and then legislators were thrilled about this.
It sort of it leads. I mean, it was an example. It was a relatively trivial example, but it got the state legislature really upset that the administrative director of the courts just sent out a memo basically saying ignore this new state law, presumably because it intruded upon the New Jersey Supreme Court's exclusive rulemaking power to determine the rules of procedure in courts, and had to do with the use of plea bargaining when and ignition lock devices for DUI cases. And the state Supreme Court perhaps prudently decided very quickly not to press the point, which sort of leads to this question. I know in New Jersey, the fact that the New Jersey Supreme Court has exclusive power to determine rules of court, and has stated at least on several occasions, and that means the legislature does not have that power. But still, usually when there is some type of tension, the court does what it can to try to, as an aspect of comedy and collegiality, to try to see if they can work it out. I wonder, Adam, if you have that speaks to sort of to your issue of collaboration. Do you have any experience on whether in other courts that have this power, that there seems to be developed this sort of dialogue between the legislature and the courts, or which, for the most part, the New Jersey courts have found a way not to constantly remind the legislature that it doesn't have rulemaking power.
Yeah, so a couple things. So Ron, thanks so much. And this is I think a great example. So a few things. So as to your question, there are absolutely other instances of courts that have kind of a relatively sophisticated way of approaching interbranch relations. So Connecticut is a really great example, in addition to New Jersey, Minnesota as well. But then there are other courts that are not so successful at this, and there's been a little bit of scholarship on this, and I think some of it actually comes back to what I discussed in the paper and I talked about today, which is kind of like how state court systems were reformed and reorganized. Is part of that reorganization in some states included just kind of like a sense of deep political engagement, not necessarily in a partisan fashion, but that, you know, we're going to have someone walk the halls in the state house or knock on the door in the governor's office, and just to kind of maintain that literal dialogue, literal conversation. And this is, you know, oftentimes due to ethical rules and things like that, cashed out as the creation of like government affairs offices or legislative liaisons, but essentially a way for the judiciary to kind of keep their finger on the pulse of kind of like what's moving through the kind of like the halls of the other branches. And New Jersey is one that has had a government affairs person essentially since the 1940s, I think it was like 1951 or something like that, and kind of served as a model, but certainly other states have developed it. Other states not as sophisticated, and as a result, don't maybe have the kind of reputation among the other branches and respect, and that can harm in some ways their relations with other branches. And coming back to my conversation with Lisa, can sometimes maybe contract how they understand their power as a result of that. But just one quick thing on the guideline 4 case that you flagged, the DWI ignition logs. So that actually implicates supervisory power as well, because even though it was Judge Grant, the chief administrative judge, you know, he serves at the pleasure of the chief, and so was kind of wielding the supervisory power there to order the trial court judges to stick to the existing rule and to kind of ignore the statute there. One interesting point, though, and I don't really know the answer to this, maybe you have thoughts or maybe others. When the court withdrew its memo, you know, there was no case. There was no challenge to the court rule or the statute. You know, they wrote that really long order that's like 50 pages long or something like that. And as you noted, I think the constitutional question was clear that the court was right. The statute was unconstitutional. But they withdrew it, and I forget the exact wording, but in the order, they seemed to kind of narrow the scope of their rulemaking power. So like, what is the precedential effect of that order? It's not a dispute, it's not a controversy. So does it have stare decisis effect, or is it like akin to like an OLC memo, like in the executive branch? Like maybe it's binding on the judiciary, but can't be enforced or kind of like marshaled in a case. I have no idea, but it's just something about that exact dispute that I've been thinking about, and I just don't know the answer.
Sarah.
I wanted to invite you to speak more about whether you think the limitations and guardrails that are currently in place are adequate. Because it's easy, a lot of people have raised sort of questions of legislatures and judiciaries not in alignment, but it's easy to imagine a world where both the legislator and the judiciary are sort of running headlong and doing things that, you know, I wouldn't like them to be doing. And I'm not sure that these sort of political remedies related to judicial elections and things like that are enough to cabin in this power if somebody gets it into their head that they do want to test the boundaries of it. Do you think they are enough, or how do you envision that?
Yeah, so this is a great question. Something I've been thinking about a little bit, because I think it kind of, you know, brings up a kind of dynamic that we've been maybe hearing a little bit more about more recently at the federal level, the, you know, kind of Levinson-Pildes separation of powers versus parties kind of concept. And the reason I think that's implicated here is I think the suit, I'd probably have to kind of come back to the project and pull out specific examples to maybe give a really precise answer to this. But my sense would be that in the kind of hypothetical that is kind of behind your question, courts wouldn't be using the supervisory power as much, because if there's alignment between the branches, they would be trying, I would maybe suspect, to entrench through other means whatever their views and policies are. So I think that would look a lot more like conventional judicial review than use of the supervisory power. But that doesn't directly answer your question about like kind of how effective are these mechanisms. I agree. I mean, I think in some instances they're not, like a true way to solve and address this. I mean, we're seeing a little bit of that right now in North Carolina, where there's a little bit of alignment between the legislature and the court. Thus far, elections haven't, there's a deeply contested election still isn't certified there. But yeah, I think in some instances they don't provide the totally adequate remedy and resolution to rein in what you might see as like state government writ large, aligned and adverse to the people that they're supposed to be representing.
Oche.
Thank you. Adam, I really appreciate your work. It has me thinking about here in Georgia in 23, lawmakers wanted to try to amend a law to like remove requirements from the state Supreme Court to approve like a commission that would dismiss or remove DAs, which was something that they were trying to push through in order, for a lack of a better words, to discipline a DA that had come up with some charges against the current administration, which was the former administration at the time. And the court, decided that they could not do that. They couldn't make that call, and they had kind of doubts about their ability to be able to regulate the duties of district attorneys. And it kind of just, your work has made me kind of reflect on that and like the misalignment of what the legislator was trying to, what the legislative branch was trying to do and what the judiciary said that they could do. And then I guess like a little bit after kind of the judiciary's decision on that, the legislator did kind of push and buck at the system and say that they would get it through and get that commission through via lawmaking instead of asking the judge to approve the panel of commission to remove the DAs. They would have it pushed through lawmaking. So your words in terms of like that kind of like soft power that previous justice had used through op-eds and things like that to flex a little bit reminded me of how in the reverse the legislators did that here, and how that could kind of be a tug of war in the media and kind of make it look like to the layman that the state government is in disarray, not really knowing about that whole supervisory power that the court has.
Thanks. I'll have to take a look at that episode. I'm not entirely familiar with it, but I absolutely take the point that many of these disputes, like the supervisory power itself, are oftentimes not, or have traditionally maybe not attracted as much attention as maybe many of us would like. And that's kind of, to a certain extent, behind a lot, certainly this paper and others, is identifying certain aspects of state institutions, especially state courts, that are really crucial and important and powerful, but oftentimes go overlooked. And so hopefully, maybe in the years ahead, we'll have more folks paying attention and engaging, not just there in Georgia, but in other states, and we'll be a little more familiar with some of the possibilities and limits of these actors, institutions, and the power that they wield.
That's great. Any other questions? Louis, you came in a little late. Do you just want to introduce yourself? have caught him when he had a different thing to do. Are there any other questions that folks have for Adam?
Yeah, I have a question. This is all very new to me, but what I'm reflecting on is the big question before us at the SCOTUS level, and that is enforcement power. And I'm wondering what the structure is or how it varies in terms of the ability of a state court to get its decisions actually followed.
That's something that I haven't studied, and is something that I'm not entirely sure. The only thing I can say, although I don't know if they'd be involved in enforcement, it's not uncommon in states for bailiffs to be within the judicial branch versus the executive branch. And so kind of like, at least at the federal level, one concern around enforcement is that they don't have any kind of guards or anyone like that. And that's not entirely true at the state level. But how that cashes out in terms of like directing them to carry out orders, I just don't know. And so I unfortunately right now I can't really venture a guess.
Well, thanks.
Where do you think this is? Where do you think? What do you think the next? This is like a totally speculative question, right? But where do you think the next 10 years on this looks like, given what the federal environment is? What does this look like in states, and why? Where will it matter the most?
Yeah. So I'll maybe say two things. I think there are kind of maybe two factors at play here that may expand or contract this kind of practice. And I'll just say that I think it's going to really differ by state, and I'll come back to that in a sec. But I think one of the factors is the political composition of the particular state. And I think it matters not just for kind of like the other branches, but also what we, the population of the various states, are asking of our courts. What are we asking them to do? What are we asking the other branches to do? And then what are the other branches maybe declining or incapable of doing for whatever reason? I think the other factor, and something that the Brennan Center has done a great job really tracking, is in many respects for state courts, we're really in a new era when it comes to campaign finance. And for kind of so that affects, of course, who's getting on these courts, and thus who's writing the decisions, who's wielding the power. And that's especially true in like battleground states, Pennsylvania, North Carolina, Wisconsin, and so on. And just the level of spending and how deeply contested these races are is really just like totally new. How that will affect the courts, how they use their power, what they understand is kind of like within their purview, how they reconceptualize their role, expanding it or narrowing it, I think really remains to be seen, because this is really kind of a post-Dobbs phenomenon. And so I think that for now, it would just be totally rank speculation in terms of the courts becoming just kind of like more entrenched in policymaking in a totally partisan and overtly partisan way, or instead the courts maybe sticking to what might be closer to like the general welfare for the state, or the courts really narrowing and really deferring to the other branches. There are other outcomes, of course, but I think it just really remains to be seen based on how those factors start to play out in the various states.
Thanks for that. Yeah, I thought it was interesting that if you think about I think the historical trajectory of all this is really interesting to me. not surprising, but the sort of the, you get these, like it has a very distinctly progressive era.
Yeah. Yep.
Like a good functioning, a well-functioning government, well-functioning professionalized state,
Yeah.
origin story that can be, that you can trace, and um, yeah, you can see how that would go. It could go in a lot of different directions, given the selection methods and process.
Totally. Yeah. And I didn't emphasize this as much during the talk, but I talk about it a little bit in the paper. But John has a really great paper, John Marshfield, on the separation of powers in the states, and Dan and what John kind of shows is that the kind of Madisonian approach to separation of powers that's kind of pervasive at the federal level, that kind of political theory of kind of contestation between the branches is just like not what is at play behind state constitutions.
Yeah.
And Dan Rodriguez, a professor at Northwestern, just had a great book. I think it just came out a couple months ago, like this fall, on the police power, the kind of primary, in some ways maybe like a sibling, the legislative sibling of the supervisory power. And in it, he has a discussion of separation of powers, and what he kind of argues is that similar to Marshfield, the kind of North Star or kind of like driving force behind interbranch relations and the kind of structure is really the general welfare, and providing for the populace rather than just like competing with one another and ambition and so forth. And I think there's something to be said for that. There's a lot more to be written. Their work is just like terrific, kind of like paving the way for more scholarship along those lines.
Yeah.
But I think how that's realized, maybe this comes back to Sarah's point a couple of minutes ago, is like, really kind of, I think, depends on what the composition of the state looks like, and the state government, I mean, and, kind of their own view of like what the general welfare requires, so to speak. And I think, how that's resolved is, maybe some of these bigger questions that we've kind of been kicking around.
Yeah. Any other closing questions or thoughts? Well, Adam, thanks so much for this. I really appreciate you doing this. This is a great paper, and I really appreciate you sharing it with us today and coming here and getting this series off to a fantastic start. So thank you for joining us today. And yeah.
Well, thank you. Thanks again for hosting, and thank you everyone for the really helpful and generative conversation and all the great comments and suggestions. I really appreciate it, and this was a lot of fun. So thank you for having me.
That's great. Thanks a lot, Adam. And thanks for joining, everybody. I'll get an email to all of you very soon, into the whole list with our schedule for the next few months. And our next event is, I was supposed to have this pulled up so I wouldn't get caught in just this spot, but we are good for, oh gosh, Jay, where's that email I sent you? I have too many emails to Jay Swanson here. Good Lord, where is that? We have, well, it'll be the last, it should be on the, oh, for heaven's sakes.
Here, Brian, is it Evan Zolden?
Yes, thank you. I have
State court partisanship and emerging interpretive tools.
Thank you so much.
That's what I'm here for.
Thank you. I am sorry. I am teaching 2 classes, and I've got a study abroad budget sheet up, and I've got a zillion Excel sheets on my. It's a miracle that this computer has not crashed. So I'll get that all out to you very soon, and and I'll get this video posted up any day now. So thanks, everybody.
Okay, bye everyone. Great seeing you all. Thank you.
Bye-bye.
Thanks so much. Take care, folks. Thank you, everybody. Thanks to Adam Sopko and everybody who sat in on this seminar this week. I thought it was a really great conversation, and I hope you enjoyed listening in on it. For the State Constitutions Lab, I am Brian Murphy. Please remember to check us out on the web at stateconstitutionslab.org. See you next month.